Good evening and welcome to True Grit Crime. I am your host, Mama Libra Scales, coming in tonight to go over some of the newest documents that had been dropped. I know I didn't go over the very last document. Um, the state's response, I believe. Anyway, we'll go through it all tonight. We will she'll go through it all. I will read it. We can have kind of like a discussion if anybody wants about the stuff. There's so much going on, with this case. There's a lot of things that need to be, I don't know, a lot of things that need to be gone over and addressed. So, um, I hope you guys have had a fabulous week. Um, Yesterday, I just went and had my procedure done, and they took a biopsy. So they said that it'll be about a week and a half before they get those results back. So I hope that they come back, everything's okay and good to go. So I'm going to pull up these documents real quick. I had it pulled up, but I think I accidentally shut it earlier. Let's see, the first one we'll go over. I'm going to pull this down and then present, share screen. That is not. Hold on. Let's see. Trying to get it to pull up. Sorry about that. All right. Now let's see if we can get it to do it. My goodness. Sometimes StreamYard is such a pain in the butt. Okay, I don't know what. I have no idea what in the world it's doing. Okay. Doesn't make any sense. I don't know. Maybe go out and come back in. I don't know. Sorry, I'm having some technical difficulties here. I think maybe because it's trying to pull it up on a separate, like, Chrome tab. So ridiculous. Okay, I think that may have done it. So let me see now. There it is. Okay. So, um, so the first one that we're going to go over, I don't know why it's doing this again. Okay, so it's the state's response to the defendant's second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. So let's see. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully objects to the defense's second motion to dismiss based upon newly discovered, destroyed, or missing exculpatory or potentially useful evidence, as would ask the court to deny the same. There is no basis in law or fact to support the defense's motion, and it should be denied. Further, there is no exculpatory evidence and or potentially useful evidence that the state has not turned over or is missing or that the state destroyed. Finally, Brad Holder is not a third-party suspect, and there is no evidence tying Brad Holder to the murder of the victims in this case. In support of said objection, the state would ask the court to consider the following. That the law, number one, that the law is clear. A dismissal of charges due to the state destroying or losing evidence is only permitted when the evidence is materially exculpatory or when the evidence is deemed potentially useful to the defense and the destruction of the evidence was done in bad faith. Chisel versus State 705 NE 2D 501 Indiana Court of Appeals 1999. Number two, the defense have not alleged any example of missing or lost evidence that is materially exculpatory or potentially useful to the case against Richard Allen, nor has the defense cited any example of the state acting in bad faith or destroying any kind of potentially useful evidence. Number three, that exculpatory evidence is defined as evidence that tends to establish a criminal defendant's innocence. State versus Durrett 923 ND 2D 449 Indiana Court of Appeals 1999. Evidence is exculpatory if it clears or tends to clear the defendant from alleged fault or guilt. Brown versus State 222 NE 3D 362 Indiana Court of Appeals 2023. For the destruction of material exculpatory evidence to support a dismissal, the material exculpatory evidence must be evidence that possess an exculpatory value that was apparent before the evidence was destroyed and must be of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. Chisel versus State 705 NE 2D 501 Indiana Court of Appeals 1999. Number four, that the evidence to be potentially useful evidence, it must be evidentiary material of which no more can be said than that it could have been subjected to tests, the results of which might have exonerated the defendant. Wade versus State 718 NE 2D 1162 Indiana Court of Appeals 1999. Quoting from Arizona versus Youngblood 488 U.S. 5157 1988. To be subject to a dismissal, law enforcement must have destroyed that potentially useful evidence in bad faith. Bad faith is defined as failing to preserve evidence pursuant to a conscious doing of wrong because of a dishonest purpose or moral obliquity. Terry versus State, 857 NE 2D 396, Indiana Court of Appeals, 2006. The defense identified 3 items of evidence that they allege were destroyed or missing, which support a dismissal, including Brad Holder's phone extraction, all evidence of Brad Holder's second interview with law enforcement, and a mimicked crime scene image found on Brad Holder's social media. They claim that these things are exculpatory or potentially useful and were destroyed by law enforcement in bad faith. Let's see. Number 6, in regards to Brad Holder's phone extraction, there is no reliable evidence that the state ever extracted data from Brad Holder's phone. The only support that the state ever possessed Brad Holder's phone is in the May 2nd, 2024 Brad Holder deposition. The defense in their motion reported that Holder indicated that he was pretty sure he turned over his phone to the police. In addition to saying that he was pretty sure, Holder went on to say, I'm not going to say that positively, but I'm pretty sure they took my phone. They took my son's and my phone. Deposition page 13. The state believes that Holder is referring to February 17th, 2017, where he and his son were both interviewed at the Delphi Police Department. On a second occasion in the deposition, Holder states that the police took both his phone and his son's phone while father and son were in the lobby of the police station on the day that they were questioned by the police. When asked how he knew the police took Logan's phone, Holder said, I'm pretty sure they did it right there in the lobby. I'm pretty sure they took both our phones. Don't quote me on that because that was a long time ago. Deposition page 14. However, documented in records previously provided in discovery, Indiana State Police Sergeant Brian Bunner collected Logan Holder's phone at Logansport High School on February 14, 2017 at 12:45 p.m. Hi, Mother of Dragons. Welcome in. I'm just getting caught up on the new documents that had been released. I hadn't been feeling well and dealing with lots, so I'm just reading these and getting caught up, and then we can have a bit of a discussion. Let's see. So Brian Bunner collected Logan Holder's phone at Logansport High School on February 14, 2017 at 12:45 p.m. Logan's mother signed the consent to search form as the parent of Logan. Brad Holder was not present. Sergeant Bunner traveled to Logansport High School and initiated contact with Logan and his mother prior to the victims' bodies being recovered in hopes data on the phone may assist police in locating the victims. Brad Holder's account of the police taking his phone is unreliable since Logan Holder's phone was seized 3 days earlier and not, as Holder insisted, contemporaneous with the taking of Brad Holder's phone. Brad Holder never says the police maintained possession of his phone or extracted data from him. The state is aware of no evidence that the police extracted data from Brad Holder's phone or ever had a possession of it. Therefore, there is no evidence that the police destroyed or lost Brad Holder's phone extraction data, much less did so in bad faith. Further, even if there had been an extraction of Brad Holder's phone that was destroyed or lost by law enforcement, there is no evidence to support the argument that data on Brad Holder's phone constituted potentially useful evidence for the defense, much less material exculpatory evidence. Despite the defense claims, there is no evidence, either physical evidence or witness statements, that connect Brad Holder to the murders or to the crime scene. There exists no nexus connecting Brad Holder to the crimes. The defense is relying on pure speculation that data on Brad Holder's phone was potentially useful to exculpate the defendant. Number 7. In regards to a second interview of Brad Holder done by law enforcement, in his deposition, Brad Holder stated that sometime he believed maybe a year or two after his first interview, he was interviewed at the Logansport Police Department by 2 Indiana State police officers, a man and a woman. The state was unaware of any such interview. In the weeks following the deposition, the state has made effort to determine if an interview of Brad Holder occurred at the Logansport Police Department. Recently, specifically May 28, 2024, ISP Detective Roland Purdy reported to investigator Steve Mullen that he and Detective Lori Lemler interviewed Brad Holder in the fall of 2017 at the Logansport Police Department. Detective Purdy stated that he had learned that Holder had previously been interviewed and the investigation ruled him out as a suspect.
Come on. In my house.
He said he and Detective Lemler met with Holder to learn more about what Holder knew about Odinism. Detective Purdy said the interview was not recorded, nor was it a formal report written. There is no support for the argument that evidence related to Brad Holder's interview at the Logansport Police Department was destroyed or lost. Neither is there any evidence that the Holder interview at Logansport Police Department resulted in any potentially useful evidence, much less materially exculpatory evidence. Finally, the defense claim that a key piece of evidence is missing, an image purportedly from Brad Holder's social media that mimics the crime scene. Hold on 1 second, y'all. Sorry, y'all. Okay, let me see. I gotta go back to this. Okay. How did I lose that? Okay. So let's see. Finally, the defense claims that a key piece of evidence is missing, an image purportedly from Brad Holder's social media that mimics the crime scene. However, the defense not only acknowledged in their motion to dismiss that the image is in their possession, but that they showed it to multiple police officers in depositions, which officers identified as coming from Brad Holder's social media. Therefore, the defense is arguing that the charges should be dismissed based upon the destruction or loss of evidence the defense currently possesses. There is no case law supporting such an argument. As stated in Chisel v. State 705 NE 2D 501 Indiana Court of Appeals of 1999, materially exculpatory evidence is that evidence which possesses an exculpatory value that was apparent before the evidence was destroyed and must be of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. Quoting from California versus Trombetta 467 U.S. 479 489 1984. Number 9, that none of this evidence that the defense saying is missing or destroyed is exculpatory evidence for the case against Richard Allen. Brad Holder is not a third-party suspect. There is no evidence that ties him to the murder of the victims in this case. The evidence ties Richard Allen to the murder of the victims in this case. Without hearing, seeking justice. Yes, without hearing is crazy to me. Number 10, that the state did not destroy or lose evidence purposely in bad faith. The motion to dismiss is replete with unfounded allegations and distorted and misinterpreted facts. The defense makes allegations that are not true and are not supported by any evidence whatsoever. The state's response to those false allegations are as follows. A, that the fact that Brad Holder gave different answers to how many times he had met Abby Williams does somehow make items A through H exculpatory. B, that there is no evidence to support that the rune on Brad Holder's hand mimics the sticks found on Abby. Further, there is no evidence to support the facts outlined in the first Frank's motion. C, that no portion of the October 26, 2022 interview of the defendant is missing. The defense has been provided with the entire recording. D, that Lieutenant Jerry Holman did not lie in his August 10th, 2023 deposition when he answered the question, was Brad Holder a suspect, with, not really, no. Lieutenant Holman went on to state on the following pages that Brad Holder wasn't really a suspect because the police had encountered him through Holder's son, who was a friend of the victims and was interviewed, and the investigation revealed he was at work at the time of the murders. Mother Dragon, sorry to hear that you haven't been feeling well. Glad to know that you are feeling better. Thank you. I'm glad to be feeling a little bit better today. Definitely, for sure. Much better than I have felt in a while. Number E, that the state has turned over to the defense that Todd Click letter and related reports and interviews after the state became aware that said items had not been previously provided. The state did not intentionally delay in providing the information to the defense, nor did the state intentionally conceal any evidence in this case. Hold on one second, guys. I got to go turn some chicken real quick. I'll be right back. Give me just a second there. Yeah. Okay. Sorry, y'all. F, the state did not attempt to conceal the identity of the Purdue professor, nor does his testimony contradict the testimony of Lieutenant Holman. This professor, Dr. Turco, has stated under oath that it is the defense who has mischaracterized his testimony rather than Lieutenant Holman. G, that the state did not intentionally delay providing the extraction data from Liberty German's phone, nor did the state conceal exculpatory evidence from said phone. H, the state did not conceal a report involving documented communication between Carroll County Prosecutor's Office investigator Steve Mullen and the Indiana State Police Trooper Blotcher, nor is the information in the communication in any way exculpatory or even potentially useful. I, that the defense's conclusion that 6.5 years after a complex criminal investigation began, officers had different recollections of what other officers believed during the investigation is somehow proof of a conspiracy to conceal officers' actual beliefs is very strange. The state does not know how that would ever be exculpatory or even potentially useful in the prosecution of Richard Allen for murder. J, that the Department of Natural Resources Officer Dan Doolin testified that he prepared a written report of his interview of the defendant, but could not locate any evidence that he had recorded his interview of the defendant, and therefore believes he did not record it. Hey, welcome in, Curious Contrarian. Let's see. Could the Department of Natural Resource Officer Dan Doolin testified he prepared a written report of his interview of the defendant, but could not locate any evidence that he had recorded his interview of the defendant and therefore believes he did not record it. However, he testified that he prepared his written report very soon after his interview and would have had no reason to destroy the recording. K, that the image that the defense believe is a mimicked crime scene image is not missing. The defense is in possession of the image. L, that Brad Holder is the key third-party suspect is false. Again, there is no evidence tying Brad Holder to the crime. The defense cannot meet its burden to even allege that he is a third-party suspect. Wherefore, the state's objection to the defense's motion to dismiss for destruction of exculpatory evidence and would ask the court to deny the same. Respectfully submitted, Nicholas McClelland. My goodness gracious. That's a mouthful there, right? So we have the newest one that was filed and released. So the next one that we have is the accused response to this court's May 31st, 2024 order of judgment of the court and notice of conflict. So I'm going to pull that one up. If it'll pull up. And why are you being a booty head? Okay, and then share my screen. Because it wants to be a booty head. Okay. All right, so we have, this one's a little bit more lengthy. Comes now the accused Richard Allen by and through counsel and files his response to this court's May 31st, 2024 order or judgment of the court and notice of conflict. In support of said motion, Mr. Allen says the following. So the introduction, number 1, on May 31st, 2024, this court issued its order or judgment of the court concerning the defense's request to have Judge Gold disqualified. Number 2, contained in said order were several errors. The defense is filing this motion to preserve those errors for future courts, if needed, and to notify the court that due to new information learned in her order, a conflict has been revealed which has caused Judge Gold to become a witness. Number 3, the defense files this response and notice for purposes of maintaining a record and does not wish for this pleading to delay future hearings from taking place, particularly hearings related to the defense request to transfer Richard Allen out of the Department of Corrections, which is the most urgent of the pending matters that need litigated. Also, the defense's response is intended to provide correct information to Judge Gold as she continues to self-evaluate her obligation to rescue herself from the case, should she believe that bias or the appearance of bias exists. And go down here to these little footnotes. So at the bottom, the footnote says, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Abney versus State 79 NE 3rd 942 951 Indiana Court of Appeals 2017, emphasis added. Judge Gohl failed to inform the defense that Carroll County Sheriff's Office fabricated facts in a report filed in her court. Number 4, in this motion to disqualify, Mr. Allen noted that according to a June 14, 2023 report filed by the Carroll County Sheriff's Office hereinafter CCSO, Judge Gohl advised the CCSO that it could ignore a valid defense subpoena for Westville Correctional Facility inmate Robert Bastin and refused to transport him to the June 15, 2023 hearing on Mr. Allen's emergency motion to modify a safekeeping order. The defense further alleged in its motion to disqualify that because of Judge Gohl's actions, the defense was without a key witness for the hearing. Number 5, it was anticipated that at the June 15, 2023 hearing, Mr. Bastin would testify as to the harsh, abusive, and unconstitutional treatment of Richard Allen at Westville Correctional Facility. Number 6, the failure of CCSO to transport the witness from Westville left Mr. Allen without crucial evidence for the hearing, thereby subverting justice for him. Number 7, however, in her May 31st, 2024 order, Judge Gohl claims that she never advised the CCSO to ignore the subpoena and leave Bastin behind. Number 8, Judge Gohl's claim contradicts the CCSO report that this court received on June 20th, 2023. The June 14, 2023 report, which was ordered by the court, stated the following. On June 14, 2023, I, Special Deputy Wysocki Bryan, while on duty, was conducting transport from Westville Correctional Facility to the Carroll County Jail. Upon my arrival, I was escorted to Bastin, Robert, DOC number 209210, segregation unit to conduct the pickup. After waiting, a corrections officer approached and told me Bastin is refusing to come out of his cell and told the corrections officer, F you can't make me go. The corrections officer told me they will do a cell extraction to get him to my transport vehicle. I told the corrections officer to stand by a second, let me make a few phone calls. I was escorted back to the main gate where I was greeted by John Gallipu. I called Carroll County Jail Commander Lori Tarzik, who said I explained the situation to them. She then made a phone call to the Chief Deputy Tobe Lesenby, who contacted Judge Francis Gohl's office to inform them of the situation. Judge Gohl's office advised to leave Bastin there if he did not want to attend the court hearing that is scheduled for 6/15/23, emphasis added. I spoke with Warden Gallepu and asked if he could provide me with a letter stating that Bastin refused to come out of his cell and he did not want to go. Warden Gallepu agreed he would. He later advised he would bring me the letter on 6/15/23 to Carroll County Courthouse so I could attach it to his report. Nothing further at this time. Number 10, the report was approved by Tobe Lesenby, who is a key witness in this case. Number 11, juxtaposed to the CCSO report is Judge Gohl's May 31st, 2024 order, in which she stated the decision by the deputy to leave without the witness was his and was not directed by the court, emphasis added. Number 12, the first time that Richard Allen's counsel learned of these contradictory stories was in Judge Gohl's May 31st, 2024 order of judgment of the court. Number 13, Judge Gohl has possessed this report since June 20th, 2023. Number 14, upon receiving this report nearly a year ago, Judge Gohl never notified Mr. Allen's attorneys of misrepresentation contained in the report as it related to her purported involvement in the failure to transport Mr. Bastin to the hearing. At the very moment of learning that CCSO filed a report with fabricated facts concerning Judge Gohl, she should have immediately alerted Mr. Allen's attorney of the misrepresentation contained in this report. 16. Further upon Judge Gohl learning of the misrepresentation contained in the report, which undetermined the evidence, Mr. Allen was able to present Judge Gohl never reset the hearing so Mr. Allen could present the very evidence Judge Gohl was lacking when she denied Mr. Allen's emergency motion to vacate safekeeping order. Number 17. Additionally, as the court is aware, Mr. Allen has filed 4 Frank's motions indicating that law enforcement has acted intentionally or in bad faith. Number 18. Also, that as this court is aware, Mr. Allen has filed 2 separate motions on dismiss based upon law enforcement's destruction of evidence. One of those motions, hey, Aurora, Bernard, y'all need to chill. Thank you. Also, as this court is aware, Mr. Allen has filed 2 separate motions to dismiss based upon law enforcement's destruction of evidence. One of these motions was heard on March 18, 2024, with the court denying said motion on April 2nd, 2024. Number 20. At the March 18, 2024 hearing, defense counsel was attempting to provide evidence to the court that the law enforcement has acted in bad faith over the course of this case. At that time, this court was aware that law enforcement had fabricated facts contained in the June 14, 2023 report, thereby acting in bad faith. Yet this court never alerted the defense, and therefore law enforcement's bad faith was not made part of the record. Number 21, even if this court would still claim that such a fabrication in a report would not have changed her ruling on the motion to dismiss, the fact is that the defense was not able to include that information on the record for the Court of Appeals, should it be necessary. Number 22, additionally, had Judge Gohl alerted Mr. Allen's attorney of Carroll County Sheriff's fabricated statement in that report, the defense could have used the fabricated statement when pursuing their Frank's motion and motion to dismiss in order to provide additional evidence of intentionality and bad faith on the part of CCSO. Number 23. Hey, Aurora, can you stop, please? Thank you. Furthermore, by failing to provide this information to Mr. Allen's attorneys, Judge Gohl prevented the defense from investigating this fabricated story, including through depositions. Number 24, Judge Gohl should have alerted Mr. Allen's attorney of CCSO's fabricated facts within their police report well before March 18, 2024 motion to dismiss, and her failure to do so provides a rational inference of bias.
Stop.
Okay, y'all, hold on. Okay. Sorry about that. Puppies want to play and jump around, and I don't want to have you guys hear like dog barking and stuff. Sorry. Okay, so let's see. Furthermore, by failing to provide this information to Mr. Allen's attorney, Judge Gohl prevented the defense from investigating this fabricated story, including through depositions. Number 24, Judge Gohl should have alerted Mr. Allen's attorney of CCSO's fabricated facts written in their police report well before March 18, 2024 motion to dismiss, and a failure to do so provides a rational inference of bias. Judge Gohl is now a witness in this matter, as to Hope Lesenby's credibility. And just before like anybody else says it, like I know that today there's been like a hot button topic of everybody saying, you know, the judge can't be made to be a witness. It's against code and um, the Indiana laws and all that stuff. But I would put forth that maybe, they are looking to have something done about this and a new judge put into place. And if a new judge is put into place, then I'm sure that they would be able to call her as a witness. I don't know. Maybe, maybe not. But that's where I tend to like go in my thought process when it comes to that. Number 25, that Judge Gold is the only individual who knows that she did not direct the CCSO office to ignore the subpoena and leave Mr. Bastin at Westville. Despite the contrary assertions in the CCSO report, she has become a witness to Tobe Lesenby's truthfulness and to the fact that the information contained in CCSO's report is false. Number 26, the credibility of a witness is always an issue for the jury. Stanley versus State, 273 IND 1318 401 ND 2D 689 692 1980. 27. If Judge Gold's story is correct, then she had a ringside seat to the intentional behavior of the CCSO and or the bad faith of the CCSO, in that it, number one, intentionally ignored a valid defense subpoena for a defense witness. And then number two, fabricated a story in a police report claiming that the sitting judge on the case authorized the CCSO to ignore the valid defense subpoena. In this scenario, Judge Gold is witness. Number 28, at future hearings and at trial, the defense should have the ability to cross-examine Tobe Lesenby on the contradictory stories with questions similar to the following. Mr. Lesenby, the defense attempted to bring a new witness named Robert Bastin to testify at a hearing concerning this observation of guards abusing Richard Allen in a variety of ways at Westville, but your office ignored a valid subpoena to bring that witness to a hearing. Isn't that right? You did not want the judge to hear the testimony of that witness because it would support the defense's contention that Richard Allen was being abused and should be moved to the Cass County Jail, closer to both his family and attorneys and away from the abuse. You wanted Richard Allen to remain in Westville prison so that he would continue to be housed far from his attorneys and family while emotionally vulnerable to the abuse he was suffering at Westville. Worse yet, you then lied in a report claiming that Judge Gold advised you that it was okay to leave Bastin behind. You lied about that in your report. Judge Gold never told you that it was okay to ignore a valid defense subpoena, did she? I'm handing you Exhibit 85, which is the June 14, 2023 report from CCSA, in which you claim that Gold gave the directive allowing you to ignore the subpoena, etc. Number 29, because the defense is claiming that law enforcement has acted in bad faith, and bad faith is an important component in its motions to dismiss, as well as the 4 Franks notices, it must be able to call Judge Gold to the stand to testify concerning the false statements contained in the CCSO's June 14, 2023 report. Judge Gold's testimony is especially vital concerning the defense's motion to modify the safekeeping order, as well as their Franks motion and motion to dismiss. Number 30, calling Judge Gold to the stand to testify as to the fabricated facts contained in this report is especially important when the very witness who is subject of this report, Robert Bastin, would have testified about Richard Allen's treatment at Westville, which directly led to the deterioration of his mental state and false statements concerning his involvement in the crime. Number 31, the defense plans on issuing subpoenas and calling Judge Gold to the stand at future hearings and at trial to testify that she never directed CCSO to ignore a valid subpoena and also never advised CCSO to leave Robert Bastin behind if he, Bastin, did not want to attend the June 15, 2024 hearing. Number 32, Judge Gold should recuse herself from this matter, and she is now a witness in the proceedings. Judge Gold's failure to admonish the CCSO may cause law enforcement to believe that they can create fabricated stories in this case with no consequences. Despite having the CCSO report since June 20th, 2023, to this day, Judge Gold has failed to admonish the CCSO for filing a report that contains such a flagrant falsehood and which is arguably an attempt to cover up their illegal action in ignoring a valid defense subpoena. Judge Gold's failure to address that fabrication in any fashion whatsoever provides a basis for a state's witness to believe that they can freely fabricate stories which subvert justice for Richard Allen without consequence. This provides a rational inference of bias. Judge Gold continues errantly to accuse the defense of improperly filing ex parte documents. In its May 31st, 2024 order, this court continued to claim that the defense is to blame for ex parte pleadings that were accessible to the prosecution. On March 7, 2024, Attorney Rossi alerted Judge Gold about his grave concerns surrounding McLeland's receiving the ex parte documents. It took Judge Gold 13 days to respond to this urgent matter. In her March 20th, 2024 email response, Judge Gold wrote to defense counsel, "I would encourage you to educate your staff on how to properly file pleadings." Attached is a printout from the DocsPop filing process of the February 26, 2024 ex parte document that court staff mishandled, causing accessibility of the document to the prosecutor, which is listed in Exhibit A. Number 38. It should be noted that upon receiving this February 26, 2024 pleading, court staff would see in bold font in capital letters at the top of the pleading the following: ex parte pleading to be placed under seal, which should have easily alerted the court staff of the ex parte's nature of the document, causing them to follow the proper procedure in processing an ex parte pleading. The staff for the defense filed the ex parte documents correctly. The DocsPop printout shows that the only service contacts listed on this ex parte filing were Brad Rossi and Andrew Baldwin, not Nicholas McLeland, James Luttrell, or Stacey Diener. Furthermore, the printout shows that all documents were marked as confidential. In her May 31st, 2024 order, Judge Gold seems to believe the parties can only file ex parte documents through the Odyssey platform. If so, she is incorrect. Parties may also file ex parte documents through the DocsPop platform, which is the platform defense staff utilized when they correctly filed the February 26, 2024 ex parte document in this case. Over the course of this case, defense staff has used both Odyssey and DocsPop platforms when e-filing ex parte documents. It is telling that the tutorial Judge Gold sent to the defense details how court staff should process ex parte documents they receive in the Odyssey platform, not the DocsPop platform. There is nothing else further that the defense can do to prevent these documents from being made public or misdirected to the prosecution. After the defense correctly files the ex parte document, the defense must then trust that the court staff has been properly trained on how to navigate an ex parte filing, whether it is filed using the Odyssey or DocsPop platform. In this case, after the defense correctly filed the ex parte motion, somehow court staff erred in how to process the document in the system, causing prosecutor McLeland to have access to the ex parte document. All right. In her May 31st, 2024 order, Judge Gold detailed how she sent the defense a tutorial paper authored by JTAC explaining the process. The court implied in said order that she sent the tutorial to the defense in order to assist the defense in learning the proper process of how to file an ex parte motion. Judge Gold's presumptions that the tutorial assisted the defense is inaccurate for 3 reasons. Number 1, the defense was not errantly filing ex parte documents. Number 2, the tutorial Judge Gold sent to the defense had nothing to do with assisting practicing lawyers on how to file ex parte documents. And number 3, the defense continued to file ex parte documents in the exact same manner it had been filing before Judge Gold ever sent the tutorial to the defense, and there were no issues. All right, give me 1 second to grab this chicken for my mama. Sorry about that, y'all. Okay, so number 43. The tutorial Judge Gold emailed to counsel is actually intended to assist court staff and clerks in how to properly handle ex parte documents after the private practitioner has filed the ex parte document. In other words, the document that Judge Gold refers to in her order does not in any way assist the practicing lawyer in filing ex parte documents, as it is a tutorial for court staff. Please find attached a printout of the tutorial Judge Gold sent the defense marked as Exhibit B, which also includes the cheat sheet referenced in the letter from Office of Court Services. Even though on its face, this tutorial clearly appears directed to assist court staff in understanding how to process and accept ex parte filings, the defense's staff still reviewed the tutorial sent by Judge Gold to determine whether any part of the tutorial was meant to assist a practicing attorney in how to file an ex parte document. It does not. When defense staff clicked on the link detailed Step 1 and attempted to sign in, they were presented with a prompt that states, "You are not authorized to use this site." This is because, again, the tutorial that Judge Gold proclaimed in her order as helpful to the defense was actually meant for court staff. In her May 31st, 2024 order, Judge Gold, referring to the email in which she provided the JTAC tutorial, stated since that communication, defense have had no issues with their staff properly filing ex parte pleadings. This court attempted to give credit to the JTAC tutorial for her claim that no ex parte issues occurred after she sent the tutorial to the defense. However, this is simply not true, as the tutorial provided no guidance for practicing lawyers, and as discussed above, the defense was already correctly filing ex parte documents. It seems likely that the actual reason for no further ex parte issues was that the court staff actually learned the proper manner in which to process an ex parte document. Judge Gold has failed to admonish Prosecutor McLeland for improperly reading ex parte pleadings while continuing to denigrate the defense counsel. The pleading errantly made accessible to Prosecutor McLeland were clearly marked ex parte. The defense became aware that Prosecutor McLeland read the ex parte documents based upon a March 6, 2024 prosecution filing in which the prosecution directly quoted from defense's ex parte filing from February 26, 2024. This document was clearly marked in capital letters at the top of the document, ex parte pleading to be placed under seal. After realizing prosecutor McLeland March 6, 2024 filing and realizing that McLeland had reviewed a defense ex parte document, Attorney Rossi sent an email to Judge Gold and one of the Judge Gold's staff members, as well as to Nick McLeland. Find attached copy of said email marked Exhibit C. The email respectfully questioned on how an ex parte motion was made accessible to the prosecution. Then on March 7, 2024, Prosecutor McLeland filed a pleading in which McLeland, finally admitted that he also had access to 3 other ex parte filings. Despite the clear markings of ex parte on the document, Prosecutor McLeland chose to read the ex parte documents rather than promptly deleting them and alerting the defense of the misdirected filing required under Indiana Rule of Professional Conduct 4.4b. A lawyer who receives a document relating to the representation of the lawyer's client and knows or reasonably should know that the document was inadvertently sent shall promptly notify the sender. After reviewing the record, the defense believes that Prosecutor McLeland actually reviewed only 2 ex parte filings, as 2 of the filings he referenced in his pleading he identified as ex parte are not actually ex parte orders. Number 50. Prosecutor McLeland never contacted the defense counsel after receiving the ex parte documents as required under IRPC 4.4b. The defense only learned of this violation upon reviewing McLeland's March 6, 2024 pleading, in which McLeland audaciously quoted directly from the ex parte document, thereby making said quote available for public view. Hi, music. How's it happening? How's it going? Good here, I think. It's a lot to get through. I'm sorry that I've had to stop a couple times for y'all, but I think it's coming along. Number 51, the act of McLeland reading from defense ex parte documents provided the prosecution with an entirely improper glimpse into the manner in which Mr. Allen's attorneys would be defending him. Yet, this is yet another example of subversion of Richard Allen's due process rights. I don't mean to be insensitive, but Abby and Libby have become beside the point. Yes, I agree. I agree that all of the shenanigans that are going on has put Abby and Libby in the back burner. And this should not be about these petty squabbles going back and forth. Well, not petty, because it does serve the fact that Richard Allen is being accused of the crime of murder. And everybody is entitled to a defense, you know? As I stated before, like, I don't know if this guy killed them. I don't know if he was involved. I don't know if he, whatever. And if he was involved, then we need to be able to just look at all of this evidence that's coming out and make a proper decision after all the evidence has been laid out. All of this back and forth is just stunting the trial from happening. And it's preventing for justice for Abby and Libby to be served right away. And you're welcome. I don't mind sharing. And I don't think that you're insensitive at all by saying that Abby and Libby have become beside the point and on the back burner, because they really have. And that's not the way that this should be going at all. Aurora, please stop. The act of McLeland reading the defense's ex parte document provided the prosecution with an entirely improper glimpse into this matter. Stop it, you guys. In which Mr. Allen's attorneys would be defending him. This is yet another example of subversion of Richard Allen's due due process rights. This court has failed to reprimand the prosecution for reading ex parte documents or to even address that issue in any way whatsoever. Nor has Judge Gold filed a pleading in which Judge Gold, publicly proclaimed that she is referring Nick McClelland to the Office of Judicial and Attorney Regulation. Executive Director Adrian Meering for that office to enforce the rules or determine counsel's ethical misconduct. This court publicly declared in its April 30th, 2024 order that it was referring defense counsel to the Office of Judicial and Attorney Regulation concerning a short and bland press release that defense counsel sent out to media sources when no gag order was in place and after the prosecution and law enforcement had conducted multiple press conferences and issued multiple press releases over the course of the investigation. Meanwhile, on the much more serious allegations of McClelland reviewing ex parte documents and violating IRPC 4.4b, Judge Gold has said or done nothing. Judge Gold is clearly treating the prosecution differently than the defense counsel, and this provides a rational inference of bias. This court offered its hand-picked public defenders an opportunity for a hearing on the Franks motion, but denied the same opportunity for attorneys Baldwin and Rossi. In her May 31st, 2024 order denying the defense's request for disqualification, the court maintained that it has no bias against the defense counsel. This quote was taken from Judge Gold's April 30th, 2024 order or judgment of the court concerning the prosecution's request to defense counsel be found in contempt. On January 22nd, 2024, the court denied Baldwin and Rossi's request for a Franks hearing. At that point in time, this court had failed to rule on the Franks request for over 4 months. Yet within 4 days of their re-entering their appearance on the case, Judge Gold denied their request without hearing. However, after Baldwin and Rossi were taken off the case in October 2023, Judge Gold informed her newly handpicked public defenders that they should review prior counsel's pleading and either adopt these pleadings or make their own. In that November 14, 2023 CCS entry, it was memorialized that Judge Gold informed the new public defenders, Scremin and Librato, that if defendants' new counsel informed the court they intend to pursue the Franks motion, the court will schedule a hearing. Emphasis added. Such actions demonstrate that this court is punishing Richard Allen due to her bias against attorneys Baldwin and Rossi, in that after they re-entered their appearances, she quickly denied Allen's original counsel a hearing on the Franks motion while offering the replacement public defenders an opportunity to have the Franks hearing after their appearance on the case. This disparate treatment of officers Baldwin and Rossi compared to this court's treatment of the prosecution and even of the replacement of public defenders provides a rational inference of bias against defense counsel Baldwin and Rossi, and therefore against Richard Allen. In its order, this court claimed that it is irrational and unreasonable for the defense to assert that a lawyer with 70 years of combined experience, they have never had a judge provide a hard end date for a trial. Calling defense counsel irrational and unreasonable shows bias, especially when the court is wrong in its understanding of jury Rule 4. The court, unfortunately, continues to malign defense counsels by calling them irrational and unreasonable for their avertments to courts around the state of Indiana never set a rigid day for a trial to end. Implicitly, the court is also averring the defense counsel are lying about their experiences in other courts around the state of Indiana. Furthermore, this court maligns defense counsel concerning its knowledge by the jury of the jury rules, when it is the court that incorrect in its assessment of the jury rules. At May 7th, 2024 pretrial hearing, the court stated, well, you understand. Well, maybe you don't understand. Jury Rule 4 requires that I issue summonses to the jury with the dates of the trial. Jury Rule 4 requires that I issue summons to the jurors with the dates. Transcript, May 7th, 2024 hearing, Part 12, line 13, emphasis added. The court cited Jury Rule 4 as a basis for limiting the time of the trial. However, Jury Rule 4 does not ever discuss the length or dates of the trial or require courts to place a hard end date for a trial. Jury Rule 4 states that not later than 7 days after the date of the drawing of names from the jury pool, the jury administrator shall mail each person whose name is drawn a juror qualification form and notice of the period during which any service may be performed. Jury Rule 4 is primarily referring to the time span or term during which citizens need to be on alert that they could be summoned in for jury duty, e.g., when they are on call for possible jury duty. The prospective juror needs to be aware that over the course of a specified number of months, the court may summon them to appear in court as a potential juror at a later date. Jury Rule 4 further states that when summoning a prospective juror in for jury duty, that the summons shall include the following information: direction to the court, parking, public transportation, compensation, court policies regarding the use of electronic communication devices, i.e. cell phone, PDA, smartphones, etc., attire, meals, and how to obtain auxiliary aids and services required by the Americans with Disabilities Act. Note that Jury Rule 4 does not require the court to provide the dates of the actual trial or the length of the actual trial, nor does Jury Rule 4 require the prospective juror to be advised of the beginning date or the end date of trial. Music says, it seems like Judge Gold does not consider there is a defendant, but only focused on the defendant's attorneys. Yeah, I would have to agree with that. And also, what I'd also have to say is, as a resident of the state of Indiana, I have a couple times received, over the last couple of years, I've received a summons for jury duty. So I have had to fill out like a jury questionnaire. And then after I filled out the jury questionnaire, the county had sent me like this letter, and they're like, okay, we received your questionnaire, and we're going to ask that you call this jury line. It's like a phone number or whatever. So you call it the night before, like before they would have court that next morning, to select members of that jury. So when you call that phone number, it would give you a prompt right then and there, and it would say, yes, they need you to report to, be selected like throughout the jury selection situation, or nope, you're safe. You don't have to show up that day. Luckily, both the times that I have called, I've gotten the, hey, we don't need you, but I think it would be cool at least once to serve on the jury. But it did also, state that like they don't give you an end date. Like there is no length set of time. Like it is your civic duty. If you are chosen for jury duty, it is your civic duty to go there and complete your service of duty. And you are there and for the duration of the trial or whatever length everything goes. So again, like I haven't seen on anything, like when I've received a jury summons, I have not received something that says, yeah, it's going to be from this date to this date. No, that's especially not on like the requests for the the questionnaire or anything like that. I've never seen anything like that specifically on any of the documents that I've received when I've been sent summons. So I hope that helps somebody to understand how that works. Jury Rule 9, terms of jury service status. A person who appears for service as a petit juror serves until the conclusion of the first trial in which the juror is sworn, regardless of the length of the trial or the manner in which the trial is deposed. Once summoned in and selected as a juror, Jury Rule 9 is the jury rule that comes the closest to referring to the length of the actual trial. Note that Jury Rule 9 places no limit to the length of actual trial once a juror is selected, nor does Jury Rule 9 place a hard end on the conclusion of any trial. Indeed, by stating that the juror serves until the end of the first trial, regardless of the length of the trial, the authors of the jury rules innately understand that courts will not have foresight to include an actual end date to a trial. As proof, in larger counties, jurors are summoned for a particular day and could be chosen to serve on any number of trials of varying lengths. Music says, if I were a defendant, I would be grateful people, potential jury would who take it seriously. Yeah. And that's one thing, like, you should take it seriously as a potential juror. Like, this is somebody's life. This is something that whatever it is that you listen to and that you take into account, you are literally making a decision that affects not just that person that's on trial's life, but the lives of their family and their friends. You know, it's a really serious thing. It's not a game at all. In spite of Judge Gould's proclamation at the May 7th, 2024 hearing, Indiana jury rules do not provide or require a mechanism to limit the length of the trial whatsoever, including as it relates to the information contained in the jury summons that the court sends to citizens pursuant to Jury Rule 4. Judge Gould's errant interpretation of the Indiana jury rules created a situation in which Mr. Allen was required to seek a continuance of his speedy trial in order to assure for himself a trial where he could thoroughly present his defense without time restrictions. Music says, and this is the state challenging an individual. Yeah, pretty much. Judge Gould's errant interpretation of Indiana jury rules create a situation in which Mr. Allen was required to seek a continuance of his speedy trial in order to assure for himself a trial where he could thoroughly present the defense without time restriction. Judge Gould's bungling of Mr. Allen's speedy trial right due to her misunderstanding of what the jury rules require in the summons only negatively affects the defendant and his constitutional rights, not the prosecution, and thus provides a rational inference of bias against the defense and Mr. Allen. In Marion County, for example, prospective jurors arrive and gather in a large room, not knowing which court or what trial they may be called upon to serve, as multiple jury trials are conducted at the same time and on the same day. The prospective juror could be asked to serve any one of those trials. And it's crazy that they refer to Marion County, because if you've ever been to Marion County for any type of court hearing or jury duty or anything like that, Marion County is an extremely hectic courthouse to have to go to for anything like that. Additionally, at the May 7th, 2024 hearing, Judge Gould cited several cases over which she presided that lasted less time than the defense is requesting on this case, essentially chastising the defense for the amount of time it was seeking for trial. The length of trial is determined by the number of witnesses, the amount of evidence, the length of the investigation, and the complexities of the issues involved. This is the state of Indiana versus Richard Allen, with its own set of facts, challenges, and potential pitfalls that could cause the trial to last beyond what the parties expect. For example, several defendants or several witnesses reside 125 miles away. If those witnesses fail to appear in spite of being properly summoned, the trial may be delayed while the parties try to determine how to deal with a witness whose car may have been broken down or who may have simply ignored a valid subpoena. These situations arise in trial, especially in a factually complex trial with approximately 185 witnesses identified by the parties. Dr. NB says this is an excellent filing. Which of the three defense attorneys do y'all think wrote it? I don't know. I don't know. Like I thought, pretty sure people were talking about that they thought Rozzy wrote it. But I don't know. It is an excellent filing. I don't know. Maybe Miss Auger wrote it. Additionally, of the approximately 185 witnesses identified by the parties, a dozen or more are expert witnesses whose testimony will generally take longer and will be more complex than fact witnesses. For this court to call defense counsel irrational and unreasonable for stating the truth that they have never had a judge set a hard end date to a trial provides a rational inference of bias against the defense. Additionally, it is shocking and disconcerting that the court refused to place a limit on the time allotted to the prosecution, but absolutely limited the time for the trial, thereby limiting Mr. Allen's time to present his defense. Under the court's prior order, the trial was to last from May 13th, 2024 through May 31st, 2024, thereby allowing approximately 13 days for opening statements, testimony, evidence, rebuttal evidence, arguing of final instructions, and closing arguments of both parties. If the prosecution took 8 days to present their case, this would only leave 5 days for Mr. Allen to present his witness, which include at least 5 experts without even factoring in rebuttal evidence, surrebuttal evidence, arguing of final instructions, and closing arguments. Dr. NB said, I was going to guess the female attorney. I'm just guessing. Yeah, I mean, I was going to guess her too, but there's a lot of people that had said that Rozzy was the one who typed this up. The hard limit on the end of the trial denies Mr. Allen his Sixth Amendment right to confront witnesses, his Sixth Amendment right to the compulsory process for witnesses, and his 14th Amendment due process right to present a defense. In the contents of its request for Judge Gold to disqualify herself, this court's maligning of defense counsel as irrational and unreasonable, when in fact was this court that was wrong in its understanding of jury rules and also wrong in its claim that courts statewide provide a hard end date to a trial, offers a rational inference bias against the defense. Music said, you know what? It shouldn't get to this argument. Well, maybe. Judge Gold's May 31st, 2024 explanation of her denial of defense motions without a hearing provides a rational inference of bias. I guess maybe before I go forward or whatever. I mean, I was at the last hearing where this whole situation went down and everybody says it's the defense's fault that they didn't move forward. You know, they're the ones that's holding this up. Actually, no, it's just simply because they could not come to an agreement of the number of days and split in the middle or anything like that. Like, again, I have to firmly say that Judge Gold was saying, listen, you're going to do this in the 15 days that I've allotted, and that's it. That's all you're going to get. And it pretty much, in my opinion, as I sat there and I witnessed this, it did push them into the corner to say, we have to forego this fast and speedy trial. You know, they have no choice. In order to get the days that they needed, they had no choice but to throw in the towel on that straight up. I mean, 185 witnesses is a lot. And that, in my opinion, is, that's going to be a long trial. There's going to be a long, long days. You know what I mean? There's going to be a lot of people to listen to and go through. So, yeah. And again, I'm still wondering if this is including, because you have to remember that there was on the list specified that there was like 100 witnesses on the prosecutor's side. And Rossi had said during that hearing, he said a lot of these witnesses that were on the list were duplicated. So does that mean, and the prosecution says, we've trimmed the fat off of it. So we think that we can get this down to 45 witnesses. So of these 45 witnesses that is separate, are you telling me that 140 witnesses are slated to testify for the defense at this point? That's a lot of witnesses. So there's a lot of information there. Judge Gold's May 31st, 2024 explanation of her denial of defense's motion without a hearing provides a rational inference of bias. In its May 31st, 2024 order, when explaining why the court denied several defense motions without hearing, the court stated, if pleadings on their face are not supported by law or admissible evidence, judicial economy does not require a hearing. This court knows very little about this case, especially compared to the lawyers litigating the matter. Therefore, how could this court determine what evidence would be admissible or inadmissible until a hearing takes place and the defense moves to admit the evidence, subject to possible objection by the prosecution? Judge Gold's claimed that defense evidence is inadmissible before conducting a hearing and before listening to the defense contextualization of the evidence surrounding their legal argument provides a rational inference of bias against the defense. This court's denial of defense motions without a hearing based upon the reasons this court cites in its May 31st, 2024 order establishes that this court is prejudging defense evidence as inadmissible. Also, this court claiming that the law does not support the defense pleadings before this court even hears any evidence is additional proof that the court is prejudging evidence. This court's denying the defense's request contained in its pleadings without a hearing based upon her prejudging evidence provides a rational inference of bias. In the future, if this court denies the defense motions based upon the court's belief that the defense pleading is not supported by law or admissible evidence, the defense requests this court to identify the evidence cited in the defense's pleading that this court believes is inadmissible, and then to explain why the court believes the evidence is inadmissible. Also, instead of simply saying denied without hearing, the defense will request the court to explain why the pleading is not supported by the law. And I think that honestly is a very reasonable request, because after each of these pleadings that have sat unheard for months and months and months on this docket, we really didn't even get a reasoning out of all of this. I thought it was very smart of the defense when they had filed the recusal for the judge. I thought it was super smart for them to forcibly make Judge Gold provide reasoning as to why she was unwilling to recuse herself. I think that it was a very smart and strategic move. It opened up for a lot of, I don't know how to say it. Like it gave the option for her in her writings and her explanation of things to see, like, as she's writing this, do you see any forms of bias or anything that jumps out at you that could be considered bias? So, Music says, no, how is it okay that the hearings are constantly expected to be denied? Spectrum of Thought says, true, but it is more like goal sabotaging. Music said the defense puts its endless detail to put it in record because they know we will be denied. Yes. Spectrum of Thought says she wants to run the clock out. Well, Nick could have taken up all the time. I don't even know what the case the state has. They should be able to rest on day one and go to lunch and eat a sandwich. Yeah, nobody knows what Nick has at this point because that's like been kept very close to the vest. And other than like the filings regarding like the confessions and the bullet, um, the striation marking on the bullet, I mean, I'm really just, I don't know, I'm struggling to see again, what they have concrete wise to even be continuing to pursue this as deep, like as hard as they are. And that's why I really just can't wait until trial comes, because that's when you are going to get down to the nitty gritty of all of this, and you're going to be able to see the evidence that they have, that they believe are the facts that prove beyond a reasonable doubt that this crime was committed by Richard Allen against the girls. um I just, I really hate that like all of this just keeps being delayed. When this finally does come to a culmination, this is going to be huge. So, even concerning something as basic as a request for a recess, Judge Gold shows favoritism to the prosecution. In her May 31st, 2024 order, Judge Gold expressed that she does not show favoritism to the prosecution. However, Judge Gold has shown her differential treatment between the prosecution and defense in a variety of ways. Some are easily identified, and some are less perceptible. For example, because cameras have not been allowed in the courtroom, it's difficult to hear Judge Gold's angry tone when addressing the defense versus how she speaks to the prosecution, and also to visualize the court's disdainful facial expressions she makes toward the defense versus the prosecution. Although it may seem petty or trivial to the court, the defense offers an example of her disparate treatment concerning something as mundane as how the court handles a simple request for a recess during a hearing. At June 15, 2023 hearing, Prosecutor McLeland requested a recess, and the following transpired. McLeland, Judge, I have two witnesses. Could I ask the court for a short recess so I could use the restroom? Would counsel approach? Judge Gold says. Sidebar conference conducted. Judge Gold, I just want to know kind of where we're at. You've got two witnesses. In the future, the defense will likely request cameras in the courtroom for all hearings and trial for purposes of transparency and to better preserve the record. McLeland, Tony Liggett and the Westfield warden. Judge Gold, okay, do we want a break for lunch? Rossi, I don't, but I'm Judge Gold. Okay. McLeland, so I don't care. I can. Inaudible. Judge Gold, yeah, we could take a quick break. How long? McLeland, I don't mean to be a pain, but. No, that's all right. How long do you think you'll be? Downstairs and right back up? No. I mean, in your witnesses, with your evidence. Oh, ding dong. I don't care how long it takes you to go there. No, I don't care about that. I don't really think too long. Inaudible. Tony about the transportation resources, and then Galepsu just to address allegations made by their safekeeping or made in their safekeeping. So like another like hour and a half? I guess I just couldn't. Let's break for lunch. I know you don't want to, but too bad. I'm fine with whatever. Okay. Okay, let's just break for lunch. I don't have anywhere else I need to be. Well, I know you don't, because you were supposed to be here for 2 days. Wow. However, At the May 7th, 2024 hearing, the court treated the defense much differently when the defense sought a short recess to confer with their client on urgent matters concerning the positive and negatives of continuing Mr. Allen's speedy trial due to Judge Gold's hard end date of May 31st, 2024. Following a back and forth exchange between Judge Gold and defense counsel concerning the defense needing more time for trial than Judge Gold was allowing, this occurred. Rossi, can we have a 5-minute recess? Judge Gold, why? Rossi, I would like to speak with my co-counsel here and have a discussion about the business issues such as scheduling, not here in a courtroom where everybody is listening to us. We've got, 50 staff members in this courtroom, people sitting behind. There's no privacy. And I'd like to talk to him in the hallway about some of the logistics of this so that we can solve this problem so that he, Mr. Allen, can put on a defense. Judge Gold, does the state of Indiana have any objection to a recess? McLeland, no, Your Honor. Judge Gold, all right. Jody, you can go off record. Judge Gold did not playfully call Brad Rossi ding dong, but instead questions Rossi's reasoning for seeking a recess. Then Judge Gold surprisingly asked the prosecutor if he, Mr. McLeland, had an objection to seeking a 5-minute recess so that the defense could talk to their client about the important matters concerning seeking a continuance of a speedy trial due to the trial court's unwillingness to provide more time to the defense at trial. Music said that judges are this. Spectrum of thoughts. Her professional conduct is lacking, but she has a huge crush on Nick. Nick's gotta go poo-poo. Dr. NB said there seems to be a spate of rogue judges in high profile criminal cases. The YSL ex parte, where the judge and DA and LEO intimidated and coerced a witness. Love the voices you're reading. Oh, thank you. Spectrum of Thoughts says Angol wants to make sure Nick doesn't get constipated, right? A court should want the whole story. Absolutely. And again, this is not something that the defense is just making up. When I sat there that day that Rossi asked her for that 5-minute recess, it wasn't even just like a casual why. It was very snarky why. She was very impatient. She did not like the fact that Rossi was asking for that time. And Rossi had to point it out to her. I have to be able to communicate with my client. And I agree with this filing. I don't care what anybody else says. As somebody who has sat there and watched these proceedings, I've witnessed all of this behavior. I've witnessed the attitude. I have witnessed the tone, the tone and inflection in her voice is beyond description than what you will read in the transcripts. I'm telling you right now, I wish that the audio was attached to this, because you can definitely hear like this frustration and this disdain that she has toward the defense. And I'm not just saying that just to say that. I literally mean that with everything, that this is the way that she acts toward them. She is rude, crude, and socially unacceptable. And she has been beyond unprofessional, in my opinion. I don't care if anybody likes the opinion. It is fact. It's not even just my opinion. It's fact. It's not appropriate. It's not okay. And I really feel like she should be learning to conduct herself in a better manner. You may not like what the defense has to present to you, but your job is to stay impartial. Your job is to look at all of the facts that have been presented in front of you, and also to make sure that everybody is getting equal time, equal, I don't know, just equal on all parts. You know what I mean? Nobody should get more than another when it comes to representing their side of the case. So, as I said before, for people who were not there, who do not witness this for themselves, it really does make it that much more frustrating and that much harder to convey to you guys. the tone and inflection in this woman's voice as she is, you know, addressing the defense. And that's not me just being like, oh, you like these people more or whatever. I don't. Like either side, to be frank with you, like honestly, all of them scare the crap out of me. All of them. Um, I just, it's insane. So, music says, hearings, listen, judge, she is lazy and so full of herself. A judge should err on the side of the defendant. Dr. NB said, we need to elect or insist on the appointment of judges with defense experience. Yeah, that would be great if we could, but you find it's not as like prevalent as you would think that it would be. But I don't know. I just, it's so much. It's so frustrating. It's like you want to have a heart attack by the end of the hearing every single time you sit and you listen to this. It just, I don't know. I get so frustrated. I really do. Um, when a defense attorney requests a 5-minute recess to talk to their client on such weighty matters as their constitutional rights related to continuing a speedy trial, it should be met with a simple, of course, and should not require approval of the prosecutor. And I agree with that. It should not require it. There should have been no extras questioning why. That she should have just said, sure, Mr. Rossi, I will grant you your 5-minute recess, and kept it moving forward. Hold on 1 second, y'all. Okay. So the court failed to address the appearance of bias, which exists in this case. Judge Gold claims in her order, as counsel should know, criminal cases are tried in a court of law, not in a court of public opinion. However, the standard for the recusal is not just whether actual bias exists, but also whether the appearance of bias exists. The judge must consider both actual bias and the appearance of bias when determining whether to disqualify herself. Judge Gold appears to conflate the general concept that on occasion the public will vehemently criticize a judge with the defense's specific contention that many in the public are particularly criticizing her for what the public perceives is actual bias against the defense. The emails which the defense attached to the motion and the means the defense referenced in the motion detailed how the public believes that Judge Gold is biased against the defense. The defense agrees with the court that general complaints by the public concerning the court's ruling should not cause her to disqualify herself. However, that is not what the defense is discussing in its motions. Although the defense believes actual bias exists, it is the appearance of bias against the defense about which the public has complained. It is the appearance of bias against the defense about which the public has written the Indiana Supreme Court. It is the appearance of bias against the defense about which the public has written Judge Gold. And it is the appearance of bias against the defense, the existence of which Judge Gold should recognize and for which Judge Gold should voluntarily recuse herself. The mere appearance of bias and partiality may require recusal if an objective person knowledgeable of all the circumstances would have a rational basis for doubling the court's partiality. Bloomington Magazine versus Klang 961 NE 2D 6164 Indiana Court of Appeals 2012. As part of the legal reasoning contained in her order, Judge Gold cites to being threatened with bodily harm and injury. She is not alone, as defense counsels have also received death threats and threats of bodily harm. Regardless, the defense sees no linkage between whether an appearance of bias exists and Judge Gold's mentioning that she and any other party has been threatened. It is true that many in the public have written both Judge Gold and the Indiana Supreme Court to complain that the judge is wrong in various rulings, particularly whether the judge should allow cameras in the courtroom. However, these complaints would not support an appearance of bias. So Music says, if the state has a beyond doubt case, then challenge them to prove it. The state has endless resources. Spectrum of Thought says she needs to get her act together. Dr. NB, judges come through the DA's office in part because police unions have such sway with their endorsements. They love violating the Hatch Act as well. Music, I'm not going to blame LE. If LE knows they are going to be put to task, they will do a thorough job. Failure to address other issues contained in the first motion to disqualify. This court addressed a few other defense issues contained in their second motion to have Judge Gold disqualify herself. The defense stands by those reasons as well and does not waive those issues for purpose of appeal. However, in its May 31st order, the court failed to address all issues contained in the defense's first motion to have Judge Gold disqualified, which the defense incorporated into its second motion. The defense requests Judge Gold to review the step and second motion to disqualify and consider whether she feels obligated to disqualify herself from the case based upon the itemized reasons contained in those motions as well as in response. Conclusion. The defense wishes to move forward and have this court conduct hearings most immediately. The request to have Richard Allen removed from DOC to either Cass or Tippecanoe County Jail while awaiting trial. This motion is intended to respond to Judge Gold's order for purpose of preserving the issues of the record so that Judge Gold may consider whether or not she feels obligated on her own to recuse herself from this case, which remains an ongoing obligation, whether or not the defense is seeking her recusal. Wherefore, the defense files its response to Judge Gold's May 31st, 2024 order or written judgment of the court concerning her denial of the defense request for disqualification. Respectfully submitted, Andrew Baldwin, Bradley Rossi, Jennifer Auger. Certificate of Service Compliance. I hereby certify that the foregoing document complies with the requirements of Trial Rule 5G with regard to information excluded from public record by Administrative Rule 9G. I certify that this was filed with the court via IEFS on June 18, 2024. I further certify that a copy of the foregoing has been provided to the following by IEFS on June 18, 2024. Nicholas McLeland, Stacy Diener, James David Luttrell, Bradley Rossi, Andrew Baldwin, and Jennifer Auger. Andrew Baldwin is at the bottom of this. The criminal defense team, Baldwin, Perry, and Wiley, 150 North Main Street, Franklin, Indiana, 46131. Okay, so we have that one. And then we're going to go over and I'm going to show you guys Exhibit A, Exhibit B, and Exhibit C so that we have those to look at. Hold on one second. I think my puppy needs to go outside. I'm so sorry to have to keep doing that. 1 second. Okay. So I'm going to let me pull up this exhibit. I don't know why it didn't already pull it up, but whatever's clever. Okay. So present. Okay. So this is Exhibit A that was shared. So at the top, it says 285 1D6 95, State of Indiana versus Richard M. Allen, 08C012210MR000001. Filing description: verified ex parte motion for hearing on funding for expert services. Motions filed. Says your filing status is accepted 2/26/2024 at 8:10 a.m. So as you can see right here, this all, I don't know why it won't let me highlight it. Each of these attachments here are marked as confidential. So down here on the second slip, there's a filing description and it's a proposed order. The filing type is ADMPROP, proposed order filed, and it was accepted on February 26, 2024 at 8:10 a.m. And again, this one was filed as confidential. Then you have a third one, which was a proposed ex parte order on funding for expert services, filed and accepted on February 26, 2024 at 8:10 a.m. And again, you can see that this order has been filed confidentially. Okay, so Dr. MB, judges come through the DA's office in part because police unions have such a sway with their endorsements. They love violating the Hatch Act. Not going to blame LE. If LE knows they are going to be put to task, they will do a thorough job, says Music. Doggies, we love them. Aw, they love you too. They're such lovers too. And then let's see. We're going to go to this other page here. So I'm going to stop. I don't know why I stopped sharing that one. But hey, it is what it is. So the next part is Exhibit B. And this one is going to be goals response to an order. Let me pull it up. Okay.
Get back.
Office of Court Services. So at the top here, this one says that it was filed on June 18th. Hold on. Let me help her real quick so that doggies don't give her a hard time. 1 second.
Dexter.
Okay. So this one says it was filed, like I said, June 18th, 2024 at 10:59 a.m. Carroll County Circuit Court, Office of Court Services. Mary Kay Hudson, Executive Director, 317-232-1313, courts.in.gov. To all judicial officers, all circuit clerks, from Jeffrey S. Weiss, Deputy Director of Legal Support and Statistics, dated March 27th, 2024. regarding proper processing of ex parte filings in Odyssey. As a reminder, ex parte is a Latin term meaning by or for one party. The term refers to an attorney or unrepresented party's communication with the judge or legal proceedings conducted without notice to and outside the presence of other parties. Typically, ex parte proceedings are permitted only when a party needs urgent relief that cannot wait until the adverse party is informed of the request and given the opportunity to respond. Ex parte court documents that are filed via e-filing or conventional filing must be handled differently than other filings. Documents that are ex parte should be marked with the document security group, access limited to court and clerk. This ensures that other parties or attorneys cannot access the filed documents. See the cheat sheet on how to process ex parte filings in your e-filing review queue in order to make sure these documents are marked properly before they are added to Odyssey. Choosing the wrong document security group will expose the filing to the other parties. If you have questions about the various document security groups in Odyssey, please contact the help desk at courts.in.gov. If you have legal questions about ex parte filings or processing ex parte documents filed on paper, please contact me, jeffrey.weiss@courts.in.gov. Please share this information with your staff. So, Odyssey CMS cheat sheet, processing ex parte filings. This is dated April 17th, 2024. Summary. Ex parte filings must be handled differently than confidential filings to ensure unintended parties do not have access to the documents. If an ex parte filing is marked confidential in Odyssey, attorneys for all parties will have access to the document. These filings must be marked with the document security group of access limited to court and clerk. The ex parte filing should be reviewed by the judge before being accepted into Odyssey to ensure the security. Once the judge has reviewed the filing, they will instruct staff on how to proceed. Important. Odyssey is software owned by Tyler Technologies Incorporation. Any screenshots of Odyssey may contain proprietary information that should not be disclosed to non-Odyssey users. Odyssey filing and serve OFS ex parte filing process. The process outlined below should only be used to process ex parte filings. Step 1, opening the envelope and forwarding it to the judge review queue. The reviewers sign into their Odyssey file and serve OFS account at https://indiana-review.fileandserve.tylertech.cloud/landing. Click the envelope number hyperlink to open this filing. So here we see that the hyperlink number is 46429, and it lists a cause number of 40C0124003F10. Of course, that's just an example. So number 3, it says click on forward located in the actions menu on the right side of the reviewer screen. Open the queue drop down menu and click on Judge Review Queue. Number 5, click on Forward. Step 2, Judge Review of Envelope. The judge signs into their Odyssey file and serve OFS accounts at the same link as above. They click the envelope number hyperlink to open the filing for the judge's review queue. The judge reviews all filings by selecting the document from the drop-down menu near the top of the reviewer's screen, then clicking on each document to review. Once the review is complete, using the process notes feature found at the top of the document. Wait a minute. Okay. The process of the notes feature found at the top of the document viewer. The judge will note instruction for the reviewer. So it shows they're processing notes as to accept or deny this motion, and then they save that note. Once the process note has been entered and saved, the judge forwards the envelope back to the appropriate review queue. Step 3. Accepting an envelope upon approval by the judge. Open the envelope as described in Step 1. An asterisk will show above the process note to indicate that the judge has added notes. Click on the process notes icon to review those notes. To process the filings, the reviewer should edit each filing. For the Access to Court Records form, Notice of Exclusion, the reviewer accepts the filing as usual and does not change the security group selected by the filer. For the ex parte motion or any ex parte documents, the reviewer selects the M, motion filed code, then unless otherwise instructed by the judge, changes the security group to access limited to court and clerk. The reviewer saves, then accepts the envelope. Once accepted, the document or documents will appear in Odyssey with the access limited to court and clerk security group. Manual ex parte filing process, scanning the document to the event. Once the judge has directed you to process the ex parte filing, creating 2 events, scanning each document to the corresponding event. For additional help, see interactive scanning in the scanning section of the Odyssey cheat sheets. When adding the ex parte motion, select the filed motion event. Do not include any comments that could identify the contents of the document. Select the access limited to court and clerk security group when scanning the document. So obviously that's where you select. When adding the notice of exclusion, select the notice of exclusion of confidential information event. Select public security group when scanning the document. So that's the instructions that were given out to help, I guess, share that stuff. Okay. And then I think that was C, right? Exhibit C. Okay. I'm just going to open this up one more time to make sure that I am, that was C. Okay. So without further ado, we have finished those sets of documents. So, if a detective knows, music said, if a detective knows he can use the judge's name to put pressure on a citizen to cough up evidence or shut up, that is an issue. I agree. Absolutely agree with that 100%. No LE officer should be able to use any name, whether it be somebody in power, to lean on someone to threaten them. Like, that's not okay. None of this is okay at all whatsoever. Thank you, Dr. NB. So does anybody have any thoughts about this? I mean, because this was like quite a wild ride of a document. And I mean, I'm in agreement from the things that I have seen, the things that I've watched happen in the courtroom. This needs to happen. In my personal opinion, I feel like Judge Cole should have already put her recusal in and stepped back from this entire ordeal. I think that the longer that she goes without doing this and the more hoops that have to be jumped through, like filing for either an original action or an interlocutory appeal, this slows down the process so much more than it should have to. I just feel like, I don't know. I just feel like she doesn't care. Like, none of this is of a major concern to her when it comes to the defense or the defendant. She's not considering anything. In my opinion, I mean, in her mind, this is already like Dunsky. This is already like slated as somebody who is guilty, and that's it. Like, that's how it makes me feel in my mind. So I don't know how it makes anybody else feel, but having issues like this is a really big problem. It's a really big problem. Imagine if you were somebody who was arrested and you went before a judge and you had to deal with these very issues. Imagine how unbelievably exhausting that would be. You know, I can't. And it is a big problem. It's a very big problem. I also find it to be a big problem that, this particular judge is looking to have a seat in the Indiana Supreme Courts. This is something that's going to help push the trajectory of her career much further. You know, the more that she has under her belt, like, the better she feels that her position is going to be in getting to that spot. And if this is how she like chooses to get there, I'd hate to see her in a position of even more power. Like, mm-mm, I just can't. I just can't with all of this. Um, that our justice system is being managed by Fran Goal. Yeah, that's scary music. It's so freaking scary to think about that. It really is. So, I don't know, like, I guess maybe these filings give like food for thought. Um, there was some other stuff that I definitely want to chit chat about and talk about, but I'm going to save that for a live for tomorrow. Um, just like new pieces of things that I've seen recently that I hadn't seen before, some things to consider. So I will catch you guys tomorrow for that. And music says, and that none of her peers are calling her out. And that's what makes it even worse, is that everybody is just okay with this happening. Nobody has said, hey, this isn't right. Stop what you're doing. None of that stuff. You know, there's a lot of people who have a lot of I don't know. They've got a lot of issues going on. So, all right, guys, I'm going to wrap this up. Thank you for watching. Thank you for listening. I hope to see you again tomorrow and in future. Have a great night.